Turning our attention to the issue of transgender rights when it comes to the battle between the states and the federal government has filed a lawsuit alleging that Tennessee's programs discriminate when it comes to transgender people. This is partially an issue the Supreme Court, of course, has also resolved as well when it came to the issue of transgender rights in the workplace. The case of Bostock, in which Justice Gorsuch wrote an opinion, which I thought was quite brilliant, dealing with the issue of how sex relates to sex discrimination when it comes to the Civil Rights Act, and noting that the Civil Rights Act prohibits discrimination on the basis of sex, and then noting that transgender to some degree might be viewed as discrimination on the basis of sex. And it was a really interesting legal opinion when it came to originalist thinking, when it came to Justice Gorsuch writing for a more textualist approach, and Justice Kavanaugh, for example, writing for what might be considered a more whole-rounded originalist approach. So perhaps exposing a difference between textualism and originalism that I hadn't really conceived of before. So it was a really, really interesting case for that reason, because it further delineated my own thinking. And I was like, I think Justice Gorsuch is actually right on this issue. So more a textualist myself than an originalist. I didn't even know there was a difference between before Gorsuch, and he clarified that. Well, anyways, some of that issue is still percolating, and the federal government has filed a lawsuit dealing with how Tennessee gives employee benefits relating to this. So let's learn a little bit more about this issue. A federal lawsuit recently filed by two people alleges the great state of Tennessee and its insurance committee are discriminating against transgender people is relations to an employee benefits program. The plaintiffs are a 30-year-old transgender woman who is an academic advisor at the University of Tennessee, and a different transgender woman who is a former special education teacher at a board of education. Both plaintiffs suffer from gender dysphoria, which is psychological distress as a result of a disconnect between a person's assigned birth and a person's perceived gender identity. The relevant physicians deemed it medically necessary for them to receive surgeries to treat their transgender dysphoria. However, the relevant plaintiffs are enrolled and were previously enrolled, as the case may be, because one of them left their job, in the state of Tennessee's comprehensive medical and hospitalization program, which denies cover of surgery or treatment for or related to a sex transformation. This only bars coverage for transgender people, according to the complaint. Okay, so we understand the issue. We've got two people who are state employees. They work for the state in various forms. You know, maybe it's local, maybe it's county, maybe it's state proper, but either way, it doesn't really matter because we've discussed this before when it comes to the issue of state level supremacy. Unlike the relationship between the federal government and the state government, where we deal with this idea of federalism, where both the state and federal governments are simultaneously sovereign. And so we run into this issue where the one can't necessarily control the other as it relates to various things. That sort of concept does not apply when it comes to states versus, for example, cities, counties, towns, or anything else. Obviously, what a state chooses to do as a matter of its own state law or its own state constitution is the state's choice. But it's the state's choice. So states can, and to some degree do, restrict themselves when it comes to these issues. But some states don't. And even where they choose to, they can choose to not do to. So states, when it comes to cities, counties, towns, and all the rest of it, are ultimately God. They can do whatever they want. There is no countervailing balance. It is up to the state's whim and mercy as to whether or not cities exist. And if they don't want them to exist, they don't have to, because that's how much control they have. So anyways, we have this Tennessee Comprehensive Medical Program, which apparently binds everyone as it relates to any kind of state work in Tennessee. Fine, no problem. We can do that. Then we say we're not going to give treatments for the sex transformations. Okay, can we do that? Well, it only applies to transgender people, but is that the same thing as discriminating against transgenderism? Because, well, you know, we're not providing it to anybody, right? We're not providing surgeries to anybody. So if we're doing it equally to everyone, maybe that's not as much a problem where it was, for example, in Bostock, where we were treating different people differently based on sex. So not clear that that falls in this domain, but then, of course, that is the legal issue. And then, of course, there is federal law as it relates to this, and the federal government is, of course, pushing in this domain. So even if Bostock doesn't go that far, which I don't think it does, the federal government would like to push the law further when it relates to the Civil Rights Act and would like to have more things covered by the Civil Rights Act than the federal courts currently recognize. So even if the law doesn't currently allow for this, they'd like to push the law in that direction, or at least that seems to be true based on their lawsuits. So all that stuff is what's happening. The plaintiffs in this case have contended that they asked the state to remove the exclusion, but the state has said, no, we're not going to do that. By denying coverage, the defendants are arguing. By denying coverage, the plaintiffs say that the state of Tennessee is in violation of the Equal Protection Clause of the 14th Amendment. Probably not. Title IX of the Education Amendment. Probably not. Title VII of the Civil Rights Act. That one is at least closer. They are asking for a trial by jury. So no, probably not on the 14th Amendment. Probably not on the Title IX. Title VII is more of your go-to, right? Prohibiting discrimination on the basis of sex in the workplace. Is this discrimination on the basis of sex in the workplace? Is it discrimination as it relates to a benefit relating to sex? Because discrimination, when it comes to sex, not only applies to the employment itself, but any benefit or any sort of advantage or any sort of asset of any variety that comes as a result of employment. So the health care would qualify as sort of a benefit, right, that comes along with employment. So yes, it is ancillary, but would be protected by Title VII. But the question is, does Title VII cover this kind of thing? Does it require the state to offer transgender surgery? They offer other kinds of surgeries, but they don't offer certain kinds of surgeries that are sex-related. Is that discrimination on the basis of sex? That's what the federal government's trying to argue. One of the plaintiffs received hormone replacement therapy. As a result, her providers contend that that treatment wasn't enough to solve the problem. So they need the gender transition surgery. So the government did offer them hormone therapy, but wouldn't do the surgeries. So we tried that and we found it wasn't enough. We need more. The coverage, of course, was denied, and the person can't pay for the surgery themselves, which regardless of whether they could or couldn't pay for the surgery themselves would not solve the issue. Even if they had enough money to pay for it out of pocket, if they're entitled to it as a benefit, they're entitled to it as a benefit. So their own ability to pay is irrelevant because it's a government offered benefit in relation to work. And so if they're entitled to it, they're entitled to it. So let's figure that out. Because of their inability to access the medical treatment they want, the person feels that their life is on hold. The unmet healthcare needs continue to weigh on their, leaving them feel stressed, anxious, depressed, and preoccupied. So they say that they're suffering mentally as a result of not getting these treatments. And they feel the treatments would help them mentally. The efficacy of that when it comes to treatments in relation to mental health in this particular domain is also somewhat questionable in this. But her own doctors, wherever they found them, she's able to find doctors that say it's medically necessary. So, okay. But just because a doctor says it's medically necessary doesn't require the state to recognize it, because states have long had the ability to regulate medical care. And states do prohibit certain medical treatments, and for a whole bunch of bases. So you can find a doctor who will approve of just about anything. It doesn't mean the state has to recognize it. The other plaintiff in this case says they fear for their life because of masculine facial features and increased scrutiny on and violence toward people who are visibly transgender, especially transgender women, and feels unsafe in public. Every time she leaves the house, she braces herself for violent attack, which, okay, I'm not really sure that leads to a legally cognizable interest in a surgery. Just because I feel like I might be subject to attack doesn't necessarily require the state to do anything about it because of no affirmative duty. So, the government doesn't generally have a duty to keep you safe. So if you feel like you're particularly vulnerable, you could tend to yourself, especially in Tennessee, where I'd like to point out that the laws relating to gun carry are not as tight as some jurisdictions. So get yourself a handgun or pepper spray or taser or something, and you can help protect yourself that way. That would be good. So talk to Pink Pistols. they can give you some interesting insights when it comes to the LGBTQ and the gun rights and gun training, because that's one of the things they do with their time. The plaintiff said in their complaint that the plaintiff continues to experience severe gender dysphoria from their facial features. The face is the first thing she looks at when she looks at in the mirror, and the first thing that other people see when they look at the person, which, okay, maybe that's true. That people look at the face first, although maybe, maybe not. Depends on how people's observations go and sort of what body feature they force look at, but they think the face is the thing. Okay. Thus, that brings us to the end for the moment of the law dealing with transgender rights as it relates to surgery, as it relates to a government provided healthcare plan for government workers. The government employs people. One of the things it offers is a healthcare plan. Federal law prohibits discrimination on the basis of sex in employment or conditions or benefits relating to employment. And so that this government provide healthcare plan, which is part of the thing that they get as being an employee, would be bound by the federal law. So the question is, in denying this surgery, are they discriminating on the basis of sex? And are countervailing considerations, like the fact that medicine is typically regulated by the state level authority, enough? Because maybe the federal law doesn't clearly erode state authority in this domain. So one of the relevant questions when it comes to this will be the issue of, did the federal government attempt to, or was it clear in co-opting authority when it came to medicine, which is typically a state level concern? And also, even if they did, is this discrimination on the basis of sex? Many interesting issues to be resolved in that domain for sure. That, for the moment, brings us to the end of discussion of this case.